I'm Alan Mendenhall. I'm president of the Montgomery chapter, and my only function is to introduce our moderator. So our moderator to my immediate left is Judge Andrew Brasher of the 11th Circuit. He's a graduate of Samford University right down the road, a graduate of Harvard Law School, clerked for Judge Pryor, was in private practice here in Birmingham for a while, served as Deputy Solicitor General under Luther Strange, and then Solicitor General from 2014 to 2019, appointed and confirmed to the Middle District. He served there 2019-2020, and in 2020 he joined the 11th Circuit. He's accomplished a lot at a young age, but he tells me all the time that the highlight of his career was the 6 months we worked together in the AG's office. Anyway, one final housekeeping announcement. I probably should have led with this. A CLE email was sent out to everybody, so if you want to get your CLE credit, go in, log in, follow instructions and all that, but make sure to check your email for that. With that, I will yield the podium.
All right.
Judge?
Does this work? Is this on? Okay. So this is the panel that you've all been waiting for. This is about federal habeas law.
Why is that funny?
Yeah. So it's my job to be the moderator of this panel. And I will say, before I introduce the panelists, there has been discovery already amongst the panelists themselves about what they're going to talk about. There have been motions filed that I've had to adjudicate. So I think that this is going to be a really lively discussion about a topic that is often wrapped up in death. All right, so to my immediate left, I'm just going to introduce everybody, and then we can kind of go in the order that we talked about speaking. So to my immediate left is Lee Kowarski. He is a professor at the University of Texas. He is the Bryant Smith Chair in Law, where he co-directs the school's Capital Punishment Center. He's an expert on habeas law. He's published many articles on habeas corpus and has co-authored 2 books, including the leading case book on habeas corpus. His scholarship has been cited by the United States Supreme Court, as well as by 7 of the federal circuit courts. He has an article forthcoming in the Harvard Law Review, which is the best law review, called The New Negative Habeas Equity, which I expect him to discuss today. Lee received his BA from Yale and his JD from the University of Virginia. After law school, he clerked for Judge Jerry Smith on the 5th Circuit. Next to him is Judge Corey Mays, who took the bench in June 2019 for the Northern District of Alabama. Before his appointment, Judge Mays had a long career of public service in the Alabama Attorney General's office. He ended his career in that office by serving as a special deputy attorney general in charge of complex civil litigation, most prominently the state's gazillion-dollar lawsuit over the massive 2010 oil spill in the Gulf of Mexico. Prior to leading that special litigation unit, Judge Mays served as the Solicitor General of Alabama, where he litigated in the U.S. Supreme Court, the 11th Circuit Court of Appeals, and Alabama's appellate courts. He earned his BA from Auburn and his JD from Georgetown. Next to him is Taylor Meehan. She is a partner at Consovoy McCarthy, where her practice focuses on constitutional litigation, appellate law, and election law. She's a former law clerk to Justice Scalia and Justice Thomas of the U.S. Supreme Court, and of course to Judge Bill Pryor of the 11th Circuit. I think we're like mandatorily required to have at least 2 prior clerks on all panels. She graduated with high honors from the University of Chicago and from the University of Missouri School of Journalism. Point of interest about Taylor: in 2021, Taylor was appointed by the U.S. Supreme Court to brief and argue a case called Patel v. Garland as an amicus, defending the reasoning of the 11th Circuit that was on review in that case. And she successfully argued that we should be affirmed, even though the United States Solicitor General and every party in the case argued that we were wrong. So, thank you, Taylor. All right, last, we have Adam Martoro. So Adam is the Forrest Gump of the conservative legal movement. He appears everywhere all at once as a litigator and a scholar. He graduated from the University of Chicago with a degree in chemistry. Then he had a master's degree in astrophysics from Cambridge on a British Marshall Scholarship. Then he decided that science was not for him, apparently. He went to law school at the University of Chicago. He graduated. He clerked for Judge Higginbotham on the 5th Circuit and then for Justice Thomas. He's been a lecturer in habeas law and federal courts at the University of Chicago since 2007. He founded his own law firm recently called Lawfare LLC. So Adam is famous for a lot of things, or infamous perhaps for a lot of things, but his most recent famous thing is that he was lead trial counsel in Students for Fair Admissions versus Harvard, So you may recall that case. I don't know if you read about it, but it's the one recently where the Supreme Court said that race-based university admissions are illegal. So that's Adam. All right, so that's our panel. Let's start with Judge Mays to give us a little bit of background on habeas law in general before we start fighting with each other about other things.
Right, that's my second problem we'll get into first. My first problem is this. I was here for the last panel, and like Judge Brasher said, I worked at the Attorney General's office a long time, and 16 years to be exact. And I would like to tell you that the best job I ever had was working for Steve Marshall, but if I do, Bill Pryor will choke. So I'm not going to do that. I enjoyed everything I got to do at that office. The other problem I have is, as you can see, I'm sitting in the middle of the table. And that was done intentionally. There is a fear that about 45 minutes into this panel, there's going to be a fight that breaks out amongst the sides. And they needed someone in the middle to take a chair to the head when it turns into all-out wrestling. So if I get hurt later, I have insurance. It's okay. Just take me straight to UAB. So how many of you have ever actually worked on a habeas case? So not quite half, but a little bit. How many of you are law students and don't even really know much about what habeas is? That's good. So my role here is this. I'm going to set the table with a little bit of background on habeas, and then you're going to hear awesome words like negative habeas equity. Is that right? That's right. And so when Judge Brasher told you that there's been a lot of discovery in this case, and that meaning this panel, he's not kidding. This is the homework that I was sent by my three fellow moderators to read to prepare for today. So I have read it, and I'm going to narrow it down to about 4 or 5 minutes for y'all. So let's start at the beginning. Federal habeas. Anybody know what habeas corpus means in Latin? Yeah, I like to say it in the southern way. It's bring me the body. That's how we would say it. Bring it to me. So back in England, it was a way that the monarch could move people around. Ultimately, the courts took that power as well so that they could bring persons in who had not been tried yet but were being held by the monarch, and we adopted it. Anybody know what part of the Constitution gives courts the power to administer habeas? There's not one. That's why Judge is over there grunting. The Constitution doesn't actually give us the right to issue writ of habeas corpus. The only mention of habeas in the Constitution is in Article 1. It says that Congress cannot suspend it. So one of the arguments I think you're probably going to hear back and forth in a little bit is, what is the writ? Why do we have it? And how much power does it give us? Most of what we're going to talk about today is the federal court's ability to issue writs of habeas for people convicted under state law. State convictions on state crimes in state prison. What power, if any, should we as federal judges have to do anything about that? And what respect do we pay to the state courts? But even in the beginning, we didn't have that power as federal judges. The writ of habeas corpus was given to federal courts in 1789, but only over federal prisoners. So for nearly the first 100 years, we federal judges could do nothing for state prisoners. It wasn't until 1867 that Congress extended it. And I think one of the first disagreements you're probably going to hear amongst my panelists is, what power did they actually give to federal judges over state prisoners? I think if you read, well, I'm not going to commentate, I'm the middleman. I'll just give it to it this way. I think a fair reading of it is to say that federal judges in the beginning only dealt with state prisoners to the extent they were being held by a court that didn't have jurisdiction, like a void jurisdiction, or they weren't being held pursuant to a judgment of the court. At least at the beginning, if there was a valid state court judgment, the federal courts didn't have power to do anything. It wasn't until really the 1950s or 60s, as substantive due process became a thing, that the court started saying that, well, to step back a second, the statute says that we have power if there is a violation of the Constitution or the laws of the United States. So as the substantive due process clause started incorporating more and more parts of the Constitution, then you can have more and more violations. For example, ineffective assistance, which we see the most often, is part of the Constitution. So if there's a violation of that, the federal court started having power to do it around the 1950s or 60s, which helped explode the amount of habeas cases that we were dealing with. In 1996, you're going to hear probably AEDPA a lot. That is when Congress tried to curtail the amount of time that it took, or really what power the federal courts had to deal with state court judgments. And as I should, because Judge Pryor will cough at me again if I don't do it, I'm going to go straight to the text so you know what we're talking about. I'm going to read you the text of 2254D, because so much of what we're about to do is probably argue about what this means that we can do. So, this is the text. An application for a writ of habeas corpus on behalf of a person in custody pursuant to the judgment of a state court shall not be granted with respect to any claim that was adjudicated on the merits in a state court proceeding unless the adjudication of the claim, and there's two parts and they're disjunctive. Number one, resulted in a decision that was contrary to or involved in unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, or resulted in a decision that was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. And the reason you hear me emphasize the word decision is I think some of the debate you're going to hear today is whether we are limited looking only at the final outcome or conclusion of the state court versus the analysis that they put in it and what that means for what we would like to see state court judges write when they write opinions. So the two things you're probably going to hear the most today, and the two things you need to think of as this panel gets going and I sort of step aside so not to get hit. The first one is, what respect, how do you give proper respect as a federal judge to state court judgments? As you've heard, we are reviewing state court decisions. So we are basically judging state court judges. And what does that mean for federalism purposes? You know, this, having been somebody who did habeas for a long time in the state attorney general's office, these proceedings take a lot of time and cost a lot of money to the state. It costs a lot of time to the victims of crime. It costs a lot of time to the defendants. You know, I've got a stat that I pulled. AEDPA in '96 was supposed to shorten the amount of time that it takes to get a case through the court system. So in 1996, the amount of time on average that it took to get a capital case from conviction to execution was 125 months. AEDPA came out in '96 to shorten that. Anybody want to take a guess what it was in 2020? If it was 125 when they passed the statute to shorten it, what do you think it was in 2020? 227, nearly double the time. So one of the questions is how effective really was it? And then the other question, and I think this is the real fundamental question you're going to hear the disagreement is, what really is habeas power? I think you're going to hear from this side of the table that we have no power but that which is given to us by Congress. And we are limited solely to that because the Constitution doesn't say anything about habeas. It doesn't give the Supreme Court jurisdiction under Article 3 or power under Article 3 to do it. That only what Congress tells us we can do, and we can only do it within the limits they give us. And I'll let the professor give his theory in a minute, but I would think you would say that habeas is a great, not only power, but duty that federal courts have that we've adopted from England. And when he talks about sort of the negative habeas equity, the problem is that the courts and Congress have tried to limit our ability to use something that was always intended for us to help those who are wrongly incarcerated. Is that fair? So it's really a top-down versus bottom-up. It's we have no power but that which is given to us. We have great power and responsibility, and it is being taken away from us. And I think that's a lot of what you're going to see back and forth. So with that, I'll let them get started.
Go for it, Lee.
So I wanted, some of what I was going to cover, I realized that Judge Mays covered. So I'm going to improvise a little bit and add something else in. But before I even start, I want to thank you all for having me. I think it's a testament to your organization that you bring in folks with viewpoints that don't align with sort of your median member. And I certainly fit that profile. Habeas corpus is historically a writ that judges use to scrutinize custody to determine whether custody is lawful. I mean, that's what it is. And, we can have arguments about the particulars, but I use the phrase habeas power, and it entails sort of three things. The first thing is the power to literally order the person detaining the prisoner to produce that prisoner in court. The second thing is the power to adjudicate the lawfulness of the detention. And the third part of the power is the power to dispense with the case in remedially creative ways. Usually it will be discharge, if they grant relief, but sometimes there are scenarios in which the allegation of the unlawful relationship isn't actually custody, and so discharge isn't quite the right remedy. We'll get into that. But those are the three sort of pillars of habeas power: bring the person to court, adjudicate lawfulness, and dispense with the remedy. Habeas worked that way for quite some time. I don't really agree with the proposition that there's this firm limit and habeas never reached convictions by jurisdictionally competent courts. The issue is instead that a conviction by a jurisdictionally competent court was all for a while that due process required. And so it wasn't that there was this category of unlawful detention that habeas power didn't reach, it was that the detention itself wasn't considered unlawful. Things worked more or less this way until, about the 1950s, the Warren Court, right? And there's some fighting about, in 1951 or 53, did the Supreme Court in this case called Brown v. Allen creatively reinterpret the federal habeas statute to permit review of convictions by courts that had jurisdiction. And there's this sort of article of faith in some communities that of course it did. And I'll just suggest that there's quite a lot of evidence that it didn't. Yickwo versus Hopkins is the most famous equal protection case, but that's actually the companion case that was also before the Supreme Court is a habeas case. They grant relief for a conviction in violation of the Equal Protection Clause. There's two cases from 1889 and 1891, where the Supreme Court says that for habeas purposes, there's no distinction between a conviction under an invalid statute and an unconstitutional application of a valid one. There are these meatpacking cases out of Louisiana where the court uses habeas to invalidate convictions because the statute is in violation of the Commerce Clause. The famous case called Moore versus Dempsey, the Supreme Court, which is 1923, I think, the Supreme Court expressly rejects the idea that habeas is exclusively for convictions that are entered by a court without jurisdiction. And in 1941, there's a case called Whaley v. Johnston, where the Supreme Court says, no, really, habeas relief can issue for any kind of constitutional error that potentially taints the conviction. I don't mean to suggest that those are the only cases. There's certainly cases that point in the other direction, but I think this idea that there's this, that 1953, in this case, Brown v. Allen, was this revolutionary rupture isn't really accurate if one sits down and looks at the cases. But the action starts after 1953 for the following reason. And that is that United States jurisdictions begin passing a lot more criminal laws. They just criminalize a lot more conduct. At the same time, the United States Supreme Court starts announcing new constitutional rules of criminal procedure and incorporating them against the states. So all of a sudden, you have this moment where there's all these people that are potentially convictable for crimes, and they have all these different constitutional rights at their disposal, and the habeas statute hasn't been updated. And so, the reaction of the federal courts was to start coming up with things that Congress hadn't enacted as a way of dealing with this explosion of habeas litigation that came out of these twin developments of more criminal law and more criminal procedure. And the Supreme Court developed things that are now familiar to us, at least if we're fluent in habeas speak, which include a non-retroactivity bar, the Teague bar, procedural default, things that the judges see every day. These are things that the Supreme Court developed as an extension of their power to develop equitable doctrines to restrict relief. Fine. The Congress has ratified those doctrines by not changing them over and over again for, 50, 100 years. But there's this really significant dicta that happens, or that started to come out of cases written by Justices Gorsuch and Justice Thomas. And that is that not only does the Supreme Court have authority to devise these equitable doctrines, but actually lower federal courts and judges have freestanding authority to deny relief when they don't think that for some reason that the prisoner is entitled to it. And that's why I call it the new negative equity, right? I think there's lots of problems with that idea. I mean, again, I'm not sure that the old negative equity was a proper exercise of power under the statute, at least as originally conceived, but it's been around forever. I think precedent's important. Congress seems fine with it. They've re-ratified the statute in face of those doctrines over and over again. Whereas this new negative equity strikes me as something altogether very different and frankly troublesome. At least if you're serious about the idea of legislative supremacy and the idea that judges should be implementing a statute that Congress ratified and passed. With that, I think I went on too long, and I'll turn it over to other folks.
Yeah, so let's hear from Adam.
Wow. Am I here? If anybody's been watching the Paxton impeachment trial knows the microphones are a big issue. The number of microphone comments that have come in the first few days of that have been way more than we've had here. First of all, thank you for everyone for having me, for Alabama for having me, for Justice Mitchell for inviting me. I will take a little bit of credit for suggesting that my great friend Lee Kowarski be invited to this. He's not only the author of the casebook that I've been using to teach this class, habeas. There's about 8 former students here in the audience, including one sitting right next to me, perhaps my finest. He's got the greatest book. He's also got some of the greatest scholarship. And there will be no fights breaking out, because one of the important things that we need to do at the Federalist Society, and I think it's a testament to the Federalist Society that Lee is here. I think it's a growing problem with the Federalist Society that we have fewer and fewer Lees at our events, and we need to get back to what it was when Judge Pryor was part of a founding group of the Federalist Society back in his Tulane days. So I'll give that little pitch. Let's get the progressives to our events. We will disagree without being disagreeable. And I must say, my own views about habeas corpus are an evolving thing. They evolve in part because the court's membership has evolved. The court's attitude towards habeas corpus has changed quite a bit in the time that I've been teaching. But I start off with a premise that I sort of arrived at, I think, when I was a law student, and certainly when I was a law clerk, which is that none of these people deserve the writ. It's evident that the answer is no, and the question is why. And I tell my law students that the first day. I say, this is a very, very complicated area of law. But if you think the answer is yes, you need to think again. And then you need to think again. And then you need to think again. And then one of them comes out to me with a Frank Easterbrook opinion granting the writ and says, well, now you've said 2 things that are incompatible. Frank Easterbrook is always right and no one should ever get the writ. And I say, well, that's when Frank Easterbrook was wrong. And as a younger man, I considered myself to be a student of Edmund Burke and Michael Oakeshott, and latterly Jeremy Bentham. And I sort of think about it from the perspective of, we have this incredibly Byzantine architecture, and really the entire purpose of the criminal justice system should be guilty people go where they belong, and innocent people do not. And that's it. And beyond that, I shouldn't care. What habeas does, particularly the kind of 20th century habeas, and actually agree a lot more with Lee than I disagree about his recitation of the history. And those of you who are my students will remember I teach Whaley. I teach that the jurisdictional test has been eroded in the early 20th century before we get to 53. But the explosion of habeas and then the negative equity that Lee's talking about leads to one of the most Byzantine areas of the law. If a student leaves law school and goes off to a clerkship, and it seems like everybody here clerked for Judge Pryor, but runs off to a clerkship, whether that's a district court for Judge Mays or the Court of Appeals, you immediately are confronted with habeas case after habeas case after habeas case. It was a profound amount of my work when I was clerking for Judge Higginbotham at the Fifth Circuit, and it is complicated. And what is complicated about it changes from era to era. You know, when I came out, AEDPA was still relatively new. A lot of the law being developed surrounded the AEDPA statute of limitations, stuff like equitable tolling or tolling, and when the statute of limitations was told is AEDPA established a 1-year limit from completing your state proceedings to filing your federal habeas petition, and that was a very Byzantine statutory area, but probably not unlike the Byzantine nature of whatever ERISA is, and I still don't know what ERISA is, and hope never to find out. But we've created this incredibly complex body of law that literally no one, starting afresh as a descriptive matter, would create. No one would. The court created these negative equity doctrines, and Lee mentioned the anti-retroactivity doctrine of the Teague case. Congress creates its own anti-retroactivity doctrine. The statute that Judge Mays read, 2254D, is written in the past tense, causes the federal habeas court to isolate its review to the actual moment that the last state court adjudicated the relevant claim. We now have 2 anti-retroactivity doctrines. Congress has created one by statute. The Supreme Court has created one by jurisprudence, and no one would create this system. So I want to point out 2 features of the system that I find quite objectionable, and then sort of propose what I would do about it if I could start again. Because I think thinking about what are we trying to achieve here, and I know what I'm trying to achieve. I want the guilty people to stay in prison, and I want the innocent people to never go. But that's just me. You may have your own sort of normative take on it. What Lee, I think, didn't get to, and I'm not sure he disagrees with, and I'm sure we'll find out, is that the negative equity, the way he's saying the new negative equity versus the old negative equity, another way to conceptualize that, and those of you who are my students will be unsurprised to hear me say this, is that Lee likes the negative equity when it was made up by the Supreme Court of the United States, so that the Supreme Court of the United States could always have the power to do whatever it perceived as justice in any particular situation. One thing to remember, and all of you will know this, the Supreme Court gets multiple chances, and I think Taylor will touch on this, multiple chances to review state prisoner convictions. They get to do that on what we call direct review, coming straight up, Illinois versus Mortara. They get to do that sometimes, and frankly, distressingly more frequently, in review of state post-conviction proceedings on certiorari. And then they get federal habeas. So the Supreme Court has multitudinous chances to address state criminal prosecutions. What they did in Teague, and as I mentioned to my students in class, is Teague purports to be about treating similarly situated people the same. We're going to have a rule that says if we create a new rule of criminal procedure, we're only going to apply it to people whose cases are then pending in the direct process. We're not going to apply it to anybody who's finished. That is a lie. People can commit the same crime on the same day and receive very different timelines for their criminal justice process. It is not about treating similarly situated people the same. It is about depriving lower federal courts of the power to create new rules of criminal procedure, because the problem the Supreme Court confronted in the late 1980s is that the Supreme Court was massively more conservative on criminal procedure than the lower federal courts were. So the Ninth Circuit could take a federal habeas case involving a state prisoner from California and make up some kooky new rule of criminal procedure and apply it in that case. And what Teague says is, no. You may not even make new rules in federal habeas cases. And who does that leave with all the power to make new rules of criminal procedure? Well, it is our lords and masters at the Supreme Court of the United States. And that, in fact, is true of pretty much of all of these negative equity doctrines, or at least the ones I think that Lee is willing to tolerate, like Teague. Maybe not so much procedural default, but in reality, still there, the Supreme Court gets a chance to hit it on direct review. The new negative equity that Professor Kowarski is talking about is the suggestion by Justices Gorsuch and Thomas that every federal judge retains a reserved discretion to deny the writ at the last step. And what Judge Oldham in the Crawford opinion that Professor Kowarski's article talks about at length says is, well, one thing a federal judge should think about at that last step, all federal judges, not just our lords and masters, is whether the petitioner is innocent or guilty. And in that sense, I'll bring this around to what I think it should be the future. We should create a system that improves upon the Bentham-esque machine that we have for criminal justice by creating a release for people whose custody truly does violate the Constitution or who are innocent. In a lot of the early cases Lee talked about, I keep thinking, well, is it custody in violation of the Constitution if you're convicted under a statute that exceeds Congress's power? Probably yes. Is it custody in violation of the Constitution if you're convicted where there was an evidentiary error in the middle of the trial that violated your Fifth Amendment right against self-incrimination, but literally you did it? No, it is not. And you should remain where you are for the rest of your days, or however many the state has said you should stay there. I think that's about all I've got before Taylor takes over. I will say the next speaker is probably the greatest lawyer of her generation, so it's a tough act to follow, but a tougher one to follow from her.
Thank you. Thank you, Mr. Mortara. Lee, I'm going to respond to you, but I'm also going to preview a few of my points because I think they're hanging together as well. Thank you so much for the invitation to be here. It's a real honor to be back in Birmingham. The greatest job I've ever had is clerking for Judge Bill Pryor.
That's what people say when they practice in the 11th Circuit. That's what I've learned.
I think I have 3 or 4 points to respond both to Lee and Mr. Mortara, and I'm fittingly also somewhat more in the middle physically here on this panel. The first is I agree with Mr. Mortara that there actually might not be too much daylight between how I read those early 20th century cases and what the Supreme Court's meaning by jurisdiction. To me, the relevant point, though, when you talk about what the habeas power is, doesn't just start in 20th century or even 19th century America. We also have to look at England. And as a young student, kid from Indiana who started trying to figure out what habeas meant, I was thinking about England, and the example that I still use today, including in our habeas class at Chicago, is if a traffic court sentences you to death, you've got a habeas problem. That is a sort of jurisdictional issue in the purest form where that traffic court has presumably gone well beyond its power to slap a fine on you for speeding and instead sentenced you to the gallows. And whenever I think about what AEDPA's doing and what we're trying to do today in habeas is the purest habeas problem is that jurisdictional power. Are you in custody pursuant to an order that went well beyond the court's power to issue? Now, that can take various forms. That might mean innocence, or I think Professor Kowarski would mean that lumps in a lot more things. And in some ways, there's some overlap. In some ways, there might be other categories that go beyond innocence. Maybe you were guilty of the traffic offense, but you still can't be sentenced to death. And so when I think about AEDPA, when I think about the negative equitable power on top of AEDPA, I always come at habeas problems with that sort of purist view of, okay, here's what it originally meant. In England, it was totally unknown that we would have sort of the life cycle of the federal habeas cases that we see now, or even state habeas cases, right, where you have a trial, and then you have a direct appeal, and then you can file a cert petition at the Supreme Court, and then you can go back for many, 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 many years in state post-conviction court, and you can get a state post-conviction court trial court, you can get new evidence, you go to the state Supreme Court, then you can go back to the United States Supreme Court. And then after, one of the cases I worked on, I think it was 15 years of that, you go back to a federal district court and you start to litigate your federal habeas petition. That sort of, and then you go to the Court of Appeals, and then you can go to the United States Supreme Court. That sort of, I think it ends up being 9, 10, or 12 different steps, was unknown in England at the time. And so when you fast forward to 1996, one of the points that Mr. Mortara is touching on is the statute we have today doesn't necessarily confer you anything more. Or perhaps the disagreement we have is the statute we have today doesn't necessarily confer you anything more than maybe what you had in England, because the statute is phrased carefully in the negative. So the statute that Judge Mays read you says you shouldn't get a habeas writ unless, or the writ shall not be granted unless. That doesn't mean the writ shall be granted if. Those are two very, very different things. And so one way to read the statute, and Professor Kowarski is going to disagree with me vehemently on this, I assume, is any judge can deny the habeas writ for various reasons. They just can't grant it unless these necessary conditions are met. But those conditions aren't necessarily sufficient, is one way to read AEDPA, which is itself a really unusual statute. And Lee's article is so interesting to me because it's not just a habeas article. It's also a statutory, the forthcoming article in the Harvard Law Review is also a statutory interpretation article, which is when we have this unique federal law that speaks in the negative, and then also starts from a place of you don't get habeas unless you're in custody in violation of the Constitution of the United States, and we can have hours-long debate of what that means. Like, how do you interpret that statutory text? And how in the world do you interpret it to allow the Supreme Court to make certain equitable habeas rules, but not every other federal judge in America? You would think it's all the same no matter what court you're in. I also just to preview some of my other thoughts, I don't just think about federal habeas today in light of England. There's other context too, which is what's going on in the state courts right now. Something interesting happened in the United States in the 1980s, 1990s, where Congress changed the United States Supreme Court's jurisdiction over that first step. So it used to be that if you were sentenced in a state court and you think your conviction violates the First Amendment or violated some other federal constitutional law, federal law, you had a right to appeal directly to the Supreme Court. It wasn't dependent on a cert petition. You were there. And so if anyone's familiar with the court's Teague jurisprudence and what we think about as like substantive new rules, like I did the thing, but to convict me of the thing is unconstitutional, all the sort of paradigmatic substantive rule cases we think about, Griswold and the flag burning case and others, they are mandatory direct appeals, or appeals as of right to the United States Supreme Court. Those aren't habeas cases. Where someone in the 60s or someone in the 70s said, I got convicted of flag burning, and so I get to go to the Supreme Court before my sentence is final. And when that went away, we also see this blossoming of federal habeas, because habeas then becomes the alternative. They didn't get their direct appeal, their cert petition was denied, and so now they have to use the post-conviction mechanism. And so one question that would be interesting is, instead of the Byzantine habeas system we have, perhaps that direct appeal makes a lot more sense nowadays. And we're seeing the Counterman case that the Supreme Court just decided is a direct criminal appeal, I believe. And so it might serve interests on both sides of the V to, again, adjudicate these somewhat core habeas issues. Have I been convicted for something that's unconstitutional? Is my conviction itself unconstitutional? Not because of something that happened in my trial, but because of the statute under which I was convicted. Why aren't we adjudicating that on a direct appeal? The second thing I would mention that I am personally familiar with is beginning in 2015, because of this fight and these overlapping rules and what does AEDPA mean, and even if AEDPA means this, we can still deny, is that's had a hydraulic effect in the state post-conviction courts. And beginning in 2015, the Supreme Court, the United States Supreme Court, reviewed a record number of decisions, not from federal habeas courts, but from state post-conviction courts. They sort of jumped the line. So in that life cycle of a habeas case where the prisoner's conviction is final, but you're in the Georgia state courts or the Alabama state courts under their state post-conviction review mechanism, the Supreme Court takes the appeal directly from there. And why does the Supreme Court do that? Because there's no AEDPA. De novo review, did they get these constitutional right? Did they get the constitutional problem right just under, applying Strickland or applying the law without AEDPA deference? And that's not surprising, right? As federal habeas clamps down, then the Supreme Court sees Batson problems or other problems that they want to review without that sort of deference. And I think both sides of the court have said that, yes, this is happening, and then there are normative differences about whether it's a good thing or a bad thing. With respect to the habeas power, one of my big questions is, okay, if we're seeing this in more activity and more review over the state habeas courts, then why do we care about AEDPA? You know, by the time you get to the state habeas courts, and if the state habeas courts are performing a reset, and then that adjudication is what we're reviewing under AEDPA, then a lot of the federal habeas problems start to fade away, and you see problems solved or remedies given more liberally in some state post-conviction courts now because of the looming oversight of the United States Supreme Court without deference, and we don't even get to some of the federal habeas debates that we've seen in the last decade.
All right, let's go to Lee. When you respond, I wonder if you could touch on two things which we brought up in the previous discussion. One is about this idea of innocence. Should habeas be something that's focused on innocence versus, a constitutional right being violated? And two, this idea of what is past practices about habeas? What does, merry old England have to do with the current process?
Can I add a third one I wanted? Part of the article that you've got coming out addresses Taylor's point about may versus shall in AEDPA. And you make a point that later on, the reason they can't say the court shall issue the writ is because later in the statute, it says you can only do it in these instances, so it would prevent you from saying you must do it. So if you can raise that too, because I thought it was an interesting back and forth on the language.
It's funny because right after the line that says, I wouldn't say that I like the Supreme Court's negative equity documents, the next 3 points are the 3 points that you brought up. And true to being a high school policy debater, I've written them in lines. Still on my faculty evaluations, I get 10x more comments that slow down, dude, than anything else. So on this question of innocence, right, I worry that people listening to Adam, I have my students call me Lee. It feels weird to hear anybody say Professor Kowarski. Lee's cool.
Back and forth.
So listening to Adam is this idea that you get a habeas petition and it's stamped this one's innocent or this one's guilty, and we then look at the claim, right? But that's an unknown variable, right? And the claims that are presented to federal judges the most are ineffective assistance of counsel claims, which require you to show prejudice, i.e. that the constitutional violation made some difference to the verdict, or some form of Brady violation or prosecutor misconduct, which also has a parallel prejudice requirement there. It's called materiality. But the point being is that to have, to even pass the pleading burden, you have to be alleging some form of innocence. And it's not like the federal judge knows this guy's innocent or this guy's not. There's a probability distribution, right? It's I'm 99.999% sure this guy's not innocent versus I don't totally know. And when you get relief, right, you're not really, in these cases, you're not discharged. Usually what you're getting is a new trial. And so, it's not as though we can say, oh, this is just for innocent people. What that means in practice is that we'd really calibrate a rule saying that we'd want new trials when we think that there's, this person has shown a likelihood of innocence by hitting this, threshold of probability. And I think then it becomes a much more difficult discussion about where is society comfortable drawing that threshold? Because we don't actually know who's innocent and who's guilty in the vast, in a lot of cases. In some, of course, we can say with 99.99% certainty that we do know. And then here's the rub. A lot of times the constitutional violation really severely implicates the degree to which we can have confidence in whether someone's innocent or guilty, right? We're talking about the prosecution suppressing evidence or a defense counsel forgetting to interview crucial witnesses or doing a required ballistics analysis or something like that. So, the grant of relief is not, the idea isn't oh, well, let's let this guy who's guilty have a new trial. It's okay, let's let this guy, and it is usually guys, avail himself of, procedures necessary to more reliably fix guilt. Now, why are we so preoccupied with that in habeas? Well, it's because when you're talking about the Sixth Amendment right to effective assistance of counsel, a lot of the information that tells you whether that happened or not isn't on the record that goes up for appeal. That's the trial counsel didn't talk to this witness or didn't do this thing. And that's like the trial counsel isn't going to attack themselves on appeal, and that's not going to be on the record. Or if the prosecutor suppressed information, it's not like the prosecutor puts it on the trial record before it goes up on appeal. They're like, Judge, I just want to make it for the record that my office is suppressing information about a jailhouse informant. Like these things don't become available until later. And that's why it's really important that we rely on post-conviction proceedings to enforce certain rights, right? So to say that habeas should only be for innocent people is in a way to say that the Sixth Amendment right to counsel is only for innocent people, and I'm not sure that's right. In terms of England, right, which is how I shorthanded Taylor's generous and thoughtful comments, I'm not sure how much England's practices should control what we do, right? We have the 1789 statute. We have the 1867 statute, which got interpreted by the Supreme Court for a really long time. Congress seems to have ratified that understanding by never changing that understanding, and it proceeded that way for quite a while, and it seems to mean something pretty different than what it meant at English common law. The second thing, and I suspect the thing that folks will be more interested to hear, is that I'm not sure this presumption that English common law didn't reach jurisdictionally sound convictions is true. Specifically, there's a guy named Paul Halliday, who's a history professor at the University of Virginia, who basically gets really irritated with the practice of just quoting what Supreme Court and King's Bench justices say about habeas practice, and he goes back and he reviews every single habeas writ for every fourth year from the year 1400 to the year 1900. And what he finds is that actually courts in England do use habeas writs to review jurisdictionally sound convictions. And I actually remember the page number because I have to quote it so many times. It is on page 118 of his book. And this isn't some marginal academic. Professor Paul Halliday is the academic that literally drove the Supreme Court's decision in Boumediene. He is repeatedly invoked by the Supreme Court as the foremost historian in the field. So this information does very serious damage to the claim that, English courts never used the habeas writ to scrutinize convictions by jurisdictionally competent courts. The last thing, the unless may thing, right? So the habeas statute says in 2241A that that judges may grant habeas relief, right? And it's the may in that provision that leads Justices Gorsuch and Thomas to say that means you're never required to get habeas relief if you otherwise check all the boxes. I think it's a pretty strained reading of the word may. It's giving may an awful lot of work to do. And the reason why I think may is in the statute is because in the following subsections, there's also language that says you cannot grant a habeas writ under certain conditions. So it would be syntactically incoherent to say that a federal judge must grant habeas relief in 2241A. It just would not be capable of being reconciled as a matter of coherent statutory drafting with subsequent provisions that say you can't grant relief if the state decision is reasonable, or you can't grant relief if the provision is untimely. I don't think it's a grand reservation of equitable authority for district courts to deny habeas relief sort of impressionistically. Indeed, when Congress wanted to award discretion in 2241, which is the habeas statute at issue, they knew how to do it because they did it. They expressly granted discretion for judges to transfer venue in 2241. And it seems like if they're going to take the trouble to express the authority to exercise discretion on a far lower stakes decision, like how to transfer venue in a habeas case, they probably would have done it with respect to the power to withhold relief for equitable reasons. So I just don't think that the may and the unless and the shall, I think we have to be really careful not to read those terms in statutory isolation, but to look at them in terms of the broader work and context of what the statute is doing. But these are all really hard questions, and I appreciate I worry that when I talk, I'm like this, like I come across sometimes as this like mirthless dude, and I'm not I'm a much better commenter than I am as a talker, and so like I really appreciate it. I appreciate the jokes about us fighting, but the joke is that like I have deep warmth and respect for both Taylor and Adams. So I'd love to hear what they say.
Can we get some warmth and respect from you? See what you say about these comments that Lee has made.
Well, first, I want to jump in. If I didn't say you were going to fight against each other, everybody would have just left. Like, oh, they all like each other. This is not fun. Well, I'm sorry, Joe. What was your question?
I just wanted your response. Yeah, I was just trying to move us along.
There's a number of great responses. Microphone. Yeah, there he is. There's a number of things that cross my mind when I hear Lee go through his recitation. The first is we may just have a kind of empirical dispute. So 99.9999999% of these people are guilty. And Aziz Huq has this wonderful article where he discusses the fact that only about 1 in 1,000 or 1 in 10,000 petitions for writs of habeas corpus are granted. And he tries to make a virtue out of the fact that we have this elaborate system that's designed to kind of find the needle in the haystack. So there's a little bit, he said it's guilty or innocent. I'm thinking that's 50-50, buddy. That's not right. The other thing is he makes the point about prejudice being built in to Strickland and Brady violations. Let's put aside the fact that there isn't actually a right to counsel. There's a right to hire your own lawyer. There's not a right to get one or have one that be that effective, but that ship sailed. I'll fight that battle a different day.
Wasn't expecting reverse Gideon versus Wainwright to come up, but
definitely wrong. Definitely should be overruled. What I think of, it's funny because Lee goes directly to the worst thing you can think of, which really the prosecution withholding exculpatory evidence. And I go directly to, I'm not saying this isn't bad, but nobody thinks a run-of-the-mill, one-off Batson violation has anything to do with whether that guy is guilty or innocent. And yet the way the law is structured and the way I think Lee wants it is that guy will get a writ of habeas corpus in a new trial 20 years after the witnesses have gone cold, some of them have died. That's exactly what happened with Thomas Joe Millerell. He killed people at a convenience store. And 20 years, more than 20 years later, he got a writ of habeas corpus because of alleged Batson violations committed by the Dallas prosecutors. Lee and I disagree about whether there were Batson violations. I don't think there were. And then, of course, the evidence had gone stale. Luckily, he basically pled out, and I think he's still in prison. But the fact of the matter is, this long delay over ticky-tack things that have nothing to do with guilt or innocence, that is a bug of the system. It's not a feature. The second point, I think we should just get out there, and Taylor can say something, and I'm sure Lee will have something to say, is one thing I do tell my students, and Lee's going to have to correct the few of you that are here to teach you the right thing if I'm telling the wrong thing, is that much of what's going on in habeas corpus is driven by capital punishment. Much of it. And the Supreme Court gave themselves an out there. You can get habeas just as to the death penalty. Why? No one knows. We made it up. So don't worry, we're not going to put actual serial killers back out on the street with these writs. We're just going to vacate their death sentences, turn them into life sentences, give the state another chance to go for capital punishment if they want to. And frequently, as is the case of Thomas Joe Millerell, the Dallas prosecutors decided not to reseek the death penalty, and that's why he remains in prison today, as opposed to having been executed. So much of habeas is the capital punishment tail wagging the dog of this entire system, where 99.99% of the prisoners are not capital prisoners, but they have to participate in this Byzantine system. And I will say, any kind of reform of habeas should probably take that into account, and should take into account the systemically bad representation that capital defendants receive. That is, of course, a product of two things. Sometimes it's the state, although, in Arizona, and I'm sure here in Alabama, the state does provide good representation for these criminal defendants. And part of it is the Crusader anti-death penalty bar, of which I am not a member, despite the fact that I'm personally opposed to the death penalty. They have a vested interest in making sure that capital defendants receive the worst lawyers possible, because they are all dead bang guilty, of course, and the way you get them out of their death penalty, the way you get rid of that death writ at the back end is to say the lawyer was terrible. And that is the entire machinery of habeas corpus is in part created to commute death sentences to life sentences. And ineffective assistance of counsel is a design of the anti-death penalty bar. They want to make sure that people don't do the work so that a federal court can come in at the last second and say, oh yeah, you had a bad lawyer, Tommy Archibald, or whoever it was. The last thing I'll say is you could believe everything Lee says, and there's no justification for federal courts doing this work. Where were the state courts during this Brady violation? Where are they? Why can't you go back to state courts? Why can't you go to the Alabama Supreme Court? Jay Mitchell will give you a fair hearing if something bad really happened. There's absolutely no reason for federal judges to put the foot on the neck of state courts and uproot their considered decision-making. We all know the following. Anytime you read an article in the New York Times about something you know about, it is false. Anytime a federal judge steps on a state judge that actually sat there, actually heard the evidence, and actually did their job, and a state appellate court that actually sat there, actually read the briefs, closer in time to what actually happened and did their job, and a state Supreme Court that did the same, they are wrong.
Can I?
You want to talk about that?
Yeah, I'll just jump in really quick, but I'm positive that Lee wants a minute to respond to what Adam
I've talked
just
too
said.
much.
The one point I just want to make, especially if you're not practicing habeas day to day or didn't do it much in a clerkship, is we haven't said this here, but just to express what is implicit, the statute itself that we live with today does not test for innocence. And so some of what Lee is saying and some of what Adam is saying is a problem with the statute. So the reason why Lee says you can't know whether they're innocent or not and they're just coming in with a Sixth Amendment claim is because that's actually what they have to do. Like that is the statutory scheme we're living in. And so I think there's lots of folks on all sides of habeas issues who say, if what we're trying to do is sort between innocence and guilt, then why do we have a statute that's coming at all sorts of procedural issues often that occur in trial? And frankly, there's currently no freestanding habeas claim that just says I'm innocent. So you raising your hand and saying I'm innocent might allow you to overcome some procedural bars with your habeas petition, but at least as things stand now, the Supreme Court in a case called Herrera has said, we're not ready to say yet that you being innocent is a freestanding claim to relief. And so that's just a fact of the statute and an interesting reform question of whether, when a federal judge is sitting on a habeas petition, maybe there should be clearer rules or Congress, it's Congress's job, not the judge's job, to figure out what sorts of claims we should really be focusing on. And Congress hasn't done that. The Supreme Court has done that. So there's you can't bring a Fourth Amendment claim in habeas. That's Stone versus Powell. That's not Congress's rule. That's the Supreme Court's rule. And so from a reform perspective, there's probably some common ground here where, yes, the statute now requires you to litigate your Batson claim to no end, but there's no similar right or similar statutory vehicle to litigate your innocence claim. The second point I'd make, and it's related to the third, is often in these discussions there's a disconnect between what habeas was in England and then what that means for what is statutorily required today and what is constitutionally required today. And the constitutional arguments are in some ways way more interesting. What's the minimum a court would have to do if someone walks into, does a federal court, if someone walks in and says, a traffic court sentenced me to death, whatever AEDPA says, is there a constitutional requirement that a court, a federal court, a state court, some court adjudicates that claim because of what was going on in England hundreds of years ago? That's a really interesting claim, or a really interesting question that at least as things stand now, barring further developments discussed in Lee's article, at least as things stand now, we're just not getting to what that constitutional floor is because AEDPA is giving you more habeas relief than that constitutional floor probably. And then related to that is just going back to the context, and going back to Adam's point, which is what are federal courts doing now in 2023 looking at these issues? And at least as far as what's constitutionally required, is it okay nowadays in 2023 for state courts to really be adjudicating those constitutional issues? And don't we expect state courts to be as capable, if not more, than federal courts in deciding whether someone needs habeas relief as a constitutional matter if AEDPA were to fade away?
Can I
Yeah,
pose
so
a question?
Judge Mays had a question he wanted to.
And it really follows exactly on what Taylor said. In reading everybody's materials, I noticed what exactly she just said, which is maybe there's common grounds between the two sides on having a habeas system that focuses on innocence. But I will give you a district judge perspective by asking two questions. If you did that, how are we supposed to deal with it? Because I get a 300-page habeas petition from a capital defendant, and paragraph 1 is, I'm actually innocent. And then I get a 250-page response from the state says, no, he isn't. And then I send them to a Rule 26 or equivalent conference, and guess what? They will never stipulate to the fact, yes, he did it. No, he didn't. So are we asking for a system in which you are now asking federal district courts to hold a second trial on the same thing? In other words, I'm going to let you have a second bite at the apple of proving your innocence in federal court where you didn't in state court. And it becomes a practical issue. I had them run the numbers. When we deal with things in the district court on the motions, in other words, when we have legal arguments, et cetera, the average or the median time that it takes the district courts in the Northern District to dispose it is 283 days. If we actually have to have a hearing and go to a verdict, it's 1,087 days. So you're adding over 800 days when you go beyond motions and into hearings. And if we start focusing on having a federal innocence trial, how much longer does it even become then? And then you get the side questions of, do we now have an ineffective assistance of innocence claim? I mean, right now we don't have ineffective assistance of post-conviction, but are we going to create a thing that we have a constitutional right to effective counsel at our innocence trial in federal court? So there's a lot of extra questions to think about when you start changing the way that it works and the way that the courts have to deal with it. So I'll let either side go first, but how would you deal with practically changing the focus of what we do?
I'm just going to take 2 seconds because I fully confess that it may be an impossible goal to create an innocence-based system without the moral hazard. Really, it's the moral hazard that Judge Mays is talking about. We all, not all of us, those of us over the age of 40 saw the Shawshank Redemption. The first thing they say is everybody's innocent. And that's the same moral hazard we had prior to AEDPA, where there was, limited abuse of the rate control. You could just file as many habeas petitions as you felt like. And if you're in prison and you got nothing better to do, you might scribble out a habeas petition. So I think it might be impossible to create an innocence-based system, but this is why I wanted to talk firstly. Right now we have a system where many of our claims, as Lee pointed out, are kind of parasitic on the likelihood of the verdict being different if the error didn't occur. And then we've got a harmless error standard for everything else. So we're already kind of looking at whether the verdict would have been different. But the one thing we're never looking at is just pure factual innocence. And it seems very weird that a guy who suffers an alleged, I'll use again, Batson violation, is somehow in a better position to vindicate his ultimate innocence, factual innocence, than a guy who's just factually innocent. And I'm really disturbed by the way our current habeas system sets up winners and losers.
So, Judge Mays, I don't think you're going to have to worry. I don't think the Supreme Court is going to create a
I was thinking
right
you were
to-
going to Congress and having them just rewrite AEDPA.
So it's important to me that we develop habeas policy in view of what sort of the median or modal or whatever, centered statistic is and not an outlier, right? So Adam keeps talking about you've got this Batson claimant and why should this Batson claimant, and he's talking specifically, his reference point is this case Thomas Joe Miller-El, which was the subject of 2 different Supreme Court opinions in 01 and 05, I think, 04 maybe. Do you know how many Batson claims the Fifth Circuit has recognized in the last 30 years?
I don't know, but Frank Easterbrook once granted the writ on a Batson claim.
Well, it's 0. I believe it's 0. And I believe that the Texas Court of Criminal Appeals is also at 0, right? So this, and if I'm wrong, I'm off by like 1 or 2.
I'm thinking of those signs you see outside of construction sites, number of days since there was an accident. That's pretty awesome.
Right, but this isn't like, the point is there's not like these Batson claimants running around getting relief, and like the number of hearings that are actually held is like really, really, really small. Similarly, right, in terms of not making policy in view of things that aren't typical, this idea that the death penalty bar, and I'm part of sort of the anti-death penalty bar, it's just not true that we like try to cede ineffective assistance of counsel so that we can argue effective assistance of counsel
Wait
later.
a second. When was the last time you saw Jenner and Block or Arnold and Porter or Hogan Lovells or any of these A-list law firms try a death penalty case, but they're always there for the habeas rescue? I mean, that's not true, Lee. These firms, these left-wing firms, who will defend Gitmo terrorists and do everything else under the sun and try to make my daughter change sex, they do not put the money in to capital defense. Jenner and Block lawyers should be at every capital trial in Alabama. Why? Because they put their money where their mouth is.
I spend a ton of time trying to recruit law firms to
And they say
take death
no, because
penalty
they want to
cases.
let them out at the back end.
That's not why they say no. It's really hard. They don't like taking particular types of death cases. There's death cases that Lee Kowarski takes that Jenner and Block's not going to take, right? Like, let's just be honest. Like, it's very hard to place a lot of these cases with firms. And there's no strategic. I mean, maybe Jenner and Block is making, and I don't know why we're singling out Jenner and Block, who's like lovely people. Maybe it's a bunch of different firms making independent decisions in their self-interest, but there's no coordinated effort on the part of the capital defense bar to cede ineffective assistance of counsel so we can argue it later. I assure you that we all believe that we're better off moving resources up front, which is the segue to my next point, which I think actually is more pertinent here, is that I think we all agree that the important work here is probably going to happen in state court, right? I mean, we can have these arguments about federal habeas, but at least in the medium term between AEDPA and the Supreme Court as currently configured, it's not the site where fact-finding is going to be particularly effective. And if we're serious about enforcing certain constitutional rights that can really only be enforced in collateral proceedings, then the site of that enforcement is going to be in state court. So, to my folks here who are deeply invested in, that part of the institutional pipeline, argue for good lawyers in state post-conviction proceedings. Argue, that fact development be reasonably funded there. These disagreements about federal habeas can get a little bit esoteric, but I really, and I do think there's important federalism concerns there, but there's also really important concerns about innocence and lawfulness, and the place to work those out, I hope, is state court.
Yeah, what about a trade like this, Lee? If you do A, B, and C, so it's AEDPA fast track. AEDPA has a provision in it that states can kind of become eligible for and receive expedited proceedings, really anti-petitioner provisions. No one's ever qualified for it. When the Democrats in the White House, the Justice Department makes it impossible. Trump had some other things that he was concerned with, and he wasn't concerned with allowing Arizona to get into AEDPA fast track. But what about this? If you do A, B, C, D, and E in your state post-conviction system, there will be no federal writ of habeas corpus available to your prisoners.
I mean, I don't know if I'd be on board with it.
You tell me what A, B, C, and D is, and then we'll get rid of it.
Well, I guess my point was just going to be that I would be okay with severely restricting the habeas privilege at the back end if there was more process on the front end. I don't know if I'd go all the way to say, like, you can categorically take it away. I don't know why.
One man's severe restriction is another man's.
But let me interject here, just for the purposes of moving us along. We've got about 5 more minutes, and I before we go, there are a lot of state judges out there, some folks in the Alabama Supreme Court, at least one friend of mine on the Georgia Supreme Court, and given that
what federal courts are doing in habeas is reviewing state court judgments. I just wanted you guys to make any pitch or thoughts that you have on what state courts should do or what they should be cognizant of when they are writing their decisions, when they are adjudicating constitutional claims in criminal cases, knowing that they will be reviewed by federal courts. Anybody want to talk about that?
Sure. If you're a state intermediate appellate court judge and you get something from your state PCR trial court and it's a 100-page opinion, you write the shortest thing you can possibly write that says absolutely nothing of substance, that says affirmed because the claims are without merit based on my independent assessment and not necessarily the reasons given by the trial court. That gives your judgment the most profound protection possible from the malfeasance of a later federal judge. Now, the reason that your state trial court judge wrote the 100-page opinion is that he or she was diligently trying to give you something that you could capably review. So that the state intermediate appellate court judges are the ones with the problem. They know that Justice Mitchell is going to ultimately review their work. And if they write essentially nothing about why they did what they did, that's a problem for the Alabama Supreme Court. Right? Or do you have a Court of Criminal Appeals? Oh, well then, sorry, it's not Justice Mitchell. You have a Texas system?
No.
One
We have an intermediate.
Oh, so it's the Tennessee system. We like that better. They're in kind of the odd position because on the one hand, you want to write for the people that are going to review your work. On the other hand, you want to preserve the judgment that the state courts have ultimately rendered, which is this man should remain where he is. I think less is more. Write the bare minimum, because then when federal court reviews it, they have to imagine every possible reason you might have done what you've done and reject every possible reason.
We have big
Whereas-
imaginations. We can imagine a lot of things.
Yeah, exactly. And it's easy. I mean, I tried to get Texas to enact a law that allowed the Texas Court of Criminal Appeals to literally stamp things denied on the merits and let people into court at any time to raise any claim they wanted, and you just use the stamp. That never happened.
Does anybody else have any thoughts on that?
I do, because I knew that was the position Adam was going to take today when asked that question. So I posed a poll to my colleagues on the Northern District, what they thought about that. And it was unanimous. They didn't agree.
Yeah.
So, no, they did not agree with the less is more. They said the more the better for us, because, and I'll give an example. What if Judge Pryor, when Taylor was there, said, here's a case that I want you to look at. I'm going to defer to whatever your ultimate decision is. And she comes back with a 2-sentence memo and said, I've read everyone's briefs and the law. I agree petitioner should win, period. Is he really going to defer to that? I mean, what's he going to have more confidence in, when she actually shows her work or when she doesn't? And that was the feeling I kept getting back from the other federal judges. Like, yes, the statute may say that we defer to the decision. Yes, go ahead.
All right, well, first, I want to say two things. One, they've been using an acronym that, for those of you who are not habeas petitioners, you may not know what it stands for. It's the Anti-Terrorism and Effective Death Penalty. That's what AEDPA is. This is why I forbid law clerks from using acronyms, in my opinion. but I would say this. I don't care what Judge Mays and his colleagues say, because I review their decisions de novo. I would do exactly what happened.
That's fine.
Yeah, I mean, honestly, Judge Mays, it sounds to me like that's the
It's the debate.
That's the disease. I mean, the fact that your colleagues want this, as opposed to just saying, no, I'll look at the state trial court, that's a 100-page opinion, that's probably right, but even if it isn't, I can think of 15 other reasons this guy should not get out. The answer is no. The question is why.
I mean, so I agree. You'll be surprised to hear that I agree with Adam from a technical standpoint, right? Like, if you are a judge and what you're interested in is ensuring that there is not going to be federal habeas relief for your judgment, write as little as possible. Because the way the federal law is structured is that, the federal judge has to imagine all the plausible explanations for the result and find that all of them are, totally unreasonable. However, that rule is built on the back of an intuition about judging that I think is correct as an empirical matter and right as a moral matter, and that is that when state court judges write opinions, they are not supposed to be thinking about how those opinions are reviewed on federal habeas. Their opinion writing practices reflect lots of deeper commitments about reason giving and judging that prompt them to offer explanations for the reason they ruled the way that they did. So, while on the one hand, I agree from a tactical perspective that what Adam is telling you is correct, if all the state court judge is concerned about is getting, reviewed on habeas, I don't think that's consistent with the spirit of judging or how most state judges, sort of see their responsibilities, which is to give reasons for applying the law the way that they end up applying it.
Well, let me ask the question to Adam and Judge Pryor. Reading the statute plainly, and I'm not saying I disagree with you, here's the pushback that I have heard, and if you look at the statute, resulted in a decision that was contrary to, comma, or involved an unreasonable application of, comma, clearly established federal law, and then 2, resulted in a decision that was based on an unreasonable determination of the facts. If the state court doesn't show its work, do we just say we can't find that it was an unreasonable application of the law because we don't know how they applied it? Or what if they don't tell us the facts? How do we know whether there was an unreasonable determination of the facts in light of the evidence if they don't tell us what their determination of the facts was? Do we just simply say it is impossible for us as a federal court to say it is unreasonable if we can't see it?
Well,
and the answer may be yes. I'm just trying to understand the theory.
You're in great company because Judge Stanley Marcus asked me that exact question the first time I argued en banc in the 11th Circuit, and my answer is this. It is absolutely the case, if you cannot imagine any rational reason why the writ was denied, that it must have ipso facto involved something that was clearly contrary to federal law, or an unreasonable application, or an unreasonable determination of the facts. Therefore, when you're faced with an unreasoned decision, you must engage in that exercise, or the petitioner cannot prove his case. And that's why the kind of paper grading exercise that a case called Terry Williams against Taylor authorized, and that Lee is referring to a little bit, is very bad for the preservation of state judgments. The only thing I'll say about what Lee said is Lee's, again, 100% correct. The question is, what's the appropriate response to the federalism violence that the writ creates in the first place? And that's where I'm not sure he stays correct.
All right. I think that's our panel. Let's give a round of applause to our panelists.